Welcome back to another episode of About the Green, episode 13 now, which is getting right into the series. We're down at St Andrews and we're here with Alice Nunn.
Hi.
So she specialises in private law, looking into trusts, estates, how to secure your personal assets and make sure that when you're trading a business, the business doesn't breach into the personal sides. We're going to have 9 holes together, play our own ball and see if we can give a bit of information to you guys. Thank you so much.
Thank you. Oh, every time.
All right, we've got 127, wind's going straight down. Well, that's going to go across the back of the green, I think. First time owner coming into a business. A lot of them will buy a business, they'll get stuck into the whole thing, start making some money, but they have no structure involved in any of it.
You should really start the conversation with your lawyer before you even buy a business, but that very rarely happens because it's sometimes an organic experience for people. But the first thing they should do is think about protecting their private assets from their commercial risk, basically. Yeah, which is usually done by way of trust, limited liability company, and there's oftentimes between the accountant and the lawyer a bit of an imbalance of what's more important, because accounting, you're going to get tax benefits, legal, you're going to get risk benefits. So it's a balance between the accounting and the law. But you definitely should think about a trust if you've got third-party kind of creditor risk or risk of third-party claims.
Yep.
Otherwise, you don't really need them. If you're not going to be sued, then you just need a company, really.
You can ultimately have your business under your name or under its own name.
Yeah, you can be a sole trader. There's too much risk in that and probably not very many tax advantages, not that I'm an accountant. So you really want a limited liability company, so you can just form a company which is relatively straightforward and then decide whether your personal assets need their own structure, usually by way of trust, to be protected from claims against your company. You have a protection in a limited liability company, being a director. There's a corporate veil, you can't get sued personally, but then there are times that you can. So, for example, health and safety breaches, criminal acts and things like that you can't insure for.
Oh, get through the tree though.
I'm just going to hit it. It's how I approach life.
That seemed really good. A little bit more juice and that probably would have fallen straight in. So you spoke about trust before. That was something I wanted to ask. Are they still relevant? They still really beneficial and valuable?
They're not as relevant as they used to be at all. There's no tax advantages now. They're at 39%. If you're trying to protect a family member, exclude a family member, you're in a blended family. So second time, third time round, and you benefit all the children. Or again, if you're in business, and that's it. And if you've got a trust now too, and you've had it for years, people are winding them up too quickly. The benefit of them might come back because it changes all the time. We're having that conversation as well a lot. There is benefit to them still, just not as much as there used to be.
So do you watch any like LPGA, PGA or anything? You got a favourite golfer?
John Daly.
He's good, eh?
Because he just doesn't care.
He doesn't. You feel like you're the female version of that?
I think so. I used to smoke too. So I would just have a cigarette hanging out of my mouth the whole round. Shot.
That was lovely. Let's see what we can do here. See if we can. Oh.
Get in.
Oh. You spoke about trusts and how sort of family relationships can come into that and how it's. What about like split up?
Trust won't help you at all.
Not at
all. You need
all.
a contracting out agreement.
So like a prenup.
Yeah, you need a prenup. Everyone does them now.
Yeah.
If someone gets offended by it, then there's probably a bigger question, to be honest. You really need a shareholders agreement if you've got more than one shareholder in your company, and that shareholders agreement should have provision around every shareholder needing a contracting out agreement to stop any issues within the business of their separations within multiple business relationships. But also sometimes people are coming in with a significant amount of KiwiSaver and loans from family or gifts from family, and that should be protected because that person didn't assist with the building of that capital. And then any future things you can do together, you can say this is relationship property, but you don't want to be losing half of your assets after a 3-year relationship because you didn't want to spend $2,000. The separations cost up. I did one. It was $1 million in legal fees. Not all mine.
Oh, what a
but,
horrible! How long did that last?
Well, it was a 4-year litigation.
Oh my god! 450 par 5. Oh.
Oh. Ah. Oh, every time.
Something that we use and ask our customers to sign against is personal guarantees.
Yeah, they're a necessary evil, I think, because people aren't going to get their finance without them. Our advice is always don't sign them. But again, the converse is they're just not going to get finance. I think it's necessary for security for lenders, but as soon as you can get it discharged, you should. And there are times when you can, as soon as the company's got more assets or there's more income and you don't need it anymore. The biggest issue is guaranteeing someone else and when you don't have control. And that usually happens in family situations where parents are going to guarantee kids and the guarantee sits there for life.
I see.
And it has to be discharged in writing. And it might be 10 years later that company does something else, that guarantee sits there and it gets called up on that guarantor.
One of the things that I see a lot of is lenders not removing their guarantee or their registrations quick enough. And ultimately, do they legally have to remove that, or does the owner have to come to them
You
and
have
say,
to ask for a discharge of the guarantee, and usually it's in the terms of the guarantee at the time of signing. Sometimes they can be enforced against the states, and they're scary, really. We don't like them.
We do, because we need them.
I know, you can take all our assets. Oops.
Oh.
You're coming with me. Oops.
Gotta hit it.